YouTube. Welcome back to the Built on Boxes YouTube channel. My name is James White. I am the trucking lawyer. Wanted to do something a little bit different today, guys. I know a lot of you guys have watched my video, The Trucking Lawyer Discusses Guns in a Commercial Vehicle. There's a murder prosecution that's going on in the state of West Virginia related to a truck driver who shot another motorist who was involved in a road rage incident in Mingo County, West Virginia. And he's actually been charged with murder, and I'm going to go through the facts of that and just kind of talk. And I'm curious to see what you guys think about this, because this is an interesting case to me, because it's a case that presents itself like it's self-defense, but we're going to go through a couple of the nuances in the code. And really, I don't want to get into a hyper legal discussion about it, but it's important because if you're going to carry a gun in a commercial vehicle, it illustrates how important it is to understand what you are legally allowed to do and what you're legally not allowed to do as it relates to defending yourself, defending your property, defending your cargo, and what you can and can't do. And all of that is relative to what state you're in. And so we're going to go through it and talk about that. But thank you guys so much for your support. Please remember to like and subscribe. And now we're going to get into the story. Now, this story comes to us from Mingo County, West Virginia. Now, just as a little bit of background, the reason that this case interests me so much is, one, I'm really interested in it because it's a self-defense shooting case involving a truck driver. Two, it's a West Virginia case, and West Virginia is where I'm from. Now, I live in Tennessee now, but I spent most of my life up till I was 35 years old in West Virginia. So I have significant connection to West Virginia, and what surprises me about this whole situation is that West Virginia is a very pro-gun state, and they've made some attempts to enact stand your ground laws. And I'm going to talk to you guys about what stand your ground actually means, how it relates to your ability to use self-defense, and how that might impact you. And this will also illustrate the truth, which is that you may be 100% justified. And I'm not saying this person is 100% justified. We're going to look at some nuances in the facts, and there's some stuff we don't know that really needs to be fleshed out before we can make a judgment. So I'm one of those people who very much, probably because I'm a lawyer, very much wants to wait for all the facts to come in before I comment one way or another as to whether or not I think this shooting was justified. And there's not a lot of information out there. This is not a high profile case. It probably should be, but it's not. What's interesting to me is that it's in West Virginia, where they're very pro-gun, and it's in Mingo County, which is very, very, very pro-gun. So I'm really surprised that the prosecutor in Mingo County has decided to bring murder charges against this guy. But we're going to talk about it and talk to you about what the Castle Doctrine means and how you can learn what your rights are. But the perfect illustration is that you can be 100% justified, and the state of wherever you are can sit on your chest for 2 or 3 or 4 years and prosecute you for homicide, even if you're right. Now, the end result might be that you get acquitted, and I believe, to be honest with you, even if some of these nuanced facts that we're going to talk about do not go in the favor of the shooter, I still think the West Virginia jury will acquit this guy. Because, again, you have people in West Virginia that are making prosecutorial decisions. Those people are lawyers. But you also have to keep in mind that the people that are going to be on a jury are people in the community. And I believe with my whole heart, everything I know about Mingo County, West Virginia, that the people of Mingo County are going to find this guy not guilty. But the point is, you can be rolling along, doing your job, out there to make money, use your gun 100% in self-defense, 100% in compliance with the law of the state you're in, and still be arrested and still be prosecuted. So that is why I suggest that people join the U.S. Concealed Carry Association. I get nothing from them. They're not sponsoring this video, but they have, for like $30 a month, they have an insurance plan that will hire a lawyer for you, that will go to bat for you in your criminal defense if you have to use your gun in self-defense if you're a member. And it's something that you guys really ought to look at and consider, because it's super important.
James Armstrong had no comment on his way to his arraignment. Anything you want to say, sir? Williamson police say Armstrong was driving this semi-truck a little before 2 Thursday afternoon when a case of road rage turned deadly. The criminal complaint says another driver, Eric Sammons, blocked Armstrong's semi at the 119 and US 52 intersection in Williamson with his car, and that Sammons walked to the driver's side of the semi, screaming and cussing.
He felt like he was threatened from the time that the big one stopped.
Armstrong's attorney says he acted in self-defense.
My client never opened the door. Mr. Sammons then, and there's witness to that effect that he was making threatening comments the whole time as he was proceeding back towards the semi. My client, like I said, never opened the door. He proceeded to open the door. He was getting physical, going to have a physical altercation, at which time my client justifiably fired a shot.
The complaint says Sammons, who lived nearby, was shot in the chest and pronounced dead at the scene. Police say Armstrong remained at the scene after the shooting and was cooperative with investigators.
As soon as he shot him, he called 911 and said, listen, I just shot somebody. I had no intent to shoot the guy, but I had no choice. I had to protect myself. I had to protect my life.
The 66-year-old from Georgia is charged with second-degree murder. The deceased man, unable to share his side of the story, but Armstrong's attorney believes the evidence will show he was within his rights to pull the trigger. Andrew Colgrove, WSAC News Channel 3, Williamson.
Well, so the Castle Doctrine is the common law's rule for how you can defend your home. And your home is your castle. And so basically, the Castle Doctrine just means that if you are presented with a threat in your home, you do not have a duty to retreat from that threat. So when you hear terms like stand your ground, and you hear terms like Castle Doctrine, the only things those really mean, the Castle Doctrine is a little different, and I'll explain the nuance, but those are really related to whether or not you are required under the law to try to retreat from the threat before you use deadly force. Now, the Castle Doctrine goes a little bit further because what it actually says in most states is that if someone presents a threat by breaking in or unlawfully entering your home, your castle, the law presumes that you have the right to use deadly force because you are justified in considering that threat to be a threat against your life or a threat to do serious bodily injury to you. So the Castle Doctrine actually creates a legal presumption in most states. And a presumption acts sort of like, you've heard of the presumption of innocence, that the law presumes that you're innocent until proven guilty. When you use deadly force inside your home in response to somebody unlawfully entering it, the law presumes that you are justified, and the burden is on the prosecution to prove that you're not justified. And just in the same way that the law presumes that you're innocent until proven guilty, the burden is on the prosecution to prove that you are not. Okay, so we're going to take a look here at the West Virginia Code. This is the section of the code that is actually considered to be the Castle Doctrine section. Now, it's really strange because this is actually codified in an area that deals with civil law, and this is only dealt with, as far as I can tell, in this area of West Virginia law. And it's titled, this is the West Virginia Legislature site, and it's titled Civil Relief for Persons Resisting Certain Criminal Activities. So it says here, a lawful occupant within a home or other place of residence is justified in using reasonable and proportionate force, including deadly force, against an intruder or attacker to prevent a forcible entry into the home or residence or to terminate the intruder or attacker's unlawful entry if the occupant reasonably apprehends that the intruder or attacker may kill or inflict serious bodily harm on the occupant or others in the home or residence, or if the occupant reasonably believes that the intruder or attacker intends to commit a felony in the home. Now, this, I would argue, does not apply to this situation. All right, so a lawful occupant within a home or place of residence does not have a duty to retreat. Again, this is not a home. It's not a place of residence. A person not engaged in any unlawful activity who is attacked in any place where he or she has a legal right to be outside of the home may use reasonable and proportionate force against an intruder, provided that such person may use deadly force against an intruder in a place that is not his home without a duty to retreat if the person reasonably, again, we have that word, believes that he or she or another is in imminent danger, meaning it's going to happen right this second, it's going to happen right now, of death or serious bodily harm from which he or she or another can only be saved by the use of deadly force. Now again, this is not a criminal code. This has nothing to do with charging a crime. This is only about whether or not you can be civilly liable or have to pay a judgment if you use deadly force against somebody. So this is going to be a really tricky situation under West Virginia law. But I think where this guy has problems, I think there's a lot of arguments to be made by a creative and intelligent prosecutor there that says, hey, look, you had the opportunity. You're 6 feet higher than this guy. You could have locked the door. You could have rolled up the window. You could have called the police. So we're going to go to the only law we have to fall back on is whether deadly force was the only way to save this guy's life. In this case, the state of West Virginia actually put forward a bill, and we're going to read the text of the bill. It's House Bill number 2564 from the 2008 session, where it actually attempted to create a stand your ground exception under West Virginia code that actually allowed you to be immune from even being prosecuted in a criminal fashion for using your gun in self-defense in an occupied vehicle. That law did not pass. I'll show you guys this because I think this code would have changed everything for this situation. These delegates attempted to introduce, well, they did introduce House Bill 2564 on January 9th, 2008. And what it was asking to do was to amend Article 2A of the West Virginia Code to include the Castle Doctrine Act. And it says the legislature finds that it is proper for law-abiding people to protect themselves and their families. They're just making notices on the record. And so it goes through a few things here. But what it actually attempted to do was it attempted to say if a person is presumed to have held a reasonable fear of imminent peril or death. Remember back when we were looking at the code that is currently there, it says that the person has to have a reasonable fear of imminent bodily injury or death. This would have made the law presume that the person had that fear. That's the way it is in Tennessee. But in West Virginia, this is what they were trying to do, but they never did it. And you come down here, it says immunity from criminal prosecution and civil action. So any person who uses force as permitted in this section is justified and is immune from criminal prosecution. So you're not even allowed to prosecute them. But basically, if you'll look here, it says that the person against whom force was used was in the process of unlawfully or forcefully entering a dwelling, residence, or occupied vehicle. Now, if this law had passed, you could make the argument that even if the door was locked, it doesn't even really matter if the door was locked. The guy was in the process of attempting to enter forcibly an occupied vehicle. And if that law had passed, I think this is absolutely a justified shooting. But because of the fact this didn't pass, there is no Section 2A. If you look up West Virginia Code, 61-2-2 is a homicide code. There is no 2A under West Virginia law. And so that's why this is going to be a very, very interesting case. But West Virginia has not actually, in spite of the fact that they're very pro-gun, has not actually carved out a protection under the criminal law for a person's ability to stand their ground and use force. Now, typically what a stand your ground rule is, it's like the Castle Doctrine in that it creates an exception to the duty to retreat. Ordinarily, under common law, if you're basically met with a deadly force threat outside of your home, you're supposed to try to retreat if it's a safely available option. You're supposed to try to move away from the threat before you use deadly force. And you can't be the primary aggressor. And so what stand your ground laws really say is that, look, if you're in a place where you're legally allowed to be, and you are not the person who started the altercation, and you're not committing any crimes, and a person presents a threat to your life or a threat to do serious bodily injury to you, you may stand your ground and you may use deadly force without a duty to retreat. Here's the kicker. In most cases, the law prescribes an objective reasonableness standard, meaning that it doesn't matter what you subjectively thought. What matters is whether or not a similarly situated person would have found it reasonable to think that the threat was a deadly threat or a threat to do serious bodily injury. But West Virginia has not passed a stand your ground criminal law, as far as I know. Now, I might be wrong. I'm completely open to being wrong. Please correct me if that's the case. There is a stand your ground law in West Virginia, but again, it is under 55722, which is civil. And every search that I was able to come up with under West Virginia law refers back to that 55722, even from the Concealed Carry Association's website. And they're usually pretty up to date on that. So what this is it's kind of a gap in West Virginia law. And we're going to find out how it plays out. So, but this guy, things that might matter. So we want to talk about the nuance. Here's what might matter. If you're in a semi, you're up probably 6 feet higher than the motorist on the ground. And if your door's locked and your window's rolled up to where they can't get in the car, if they reach out and they grab and pull on the handle and they attempt to break into your truck, would an objectively reasonable person think that they were in imminent danger of having their life threatened or undertaking serious bodily injury? And I would argue probably not. And so because that is what the law says in West Virginia, it begs the question, what actually happened here? We don't know. What we know is that the person either attempted to or began to open the door. Now, we've got a young motorist, like late 20s, early 30s, that's substantially larger than our truck driver, and we've got a 67-year-old truck driver from out of state. So I think in that case, you can make the argument that if this guy actually did open the door and he was advancing into the truck, you could say, look, he's bigger, stronger, he's younger, I'm older, I'm not from here, I don't know anybody, I don't know anything. He drags me out of this truck, that's definitely seriously bodily injury, and it's definitely a threat to my life. He could drag me into traffic, he could beat me to death, he could have a weapon if he gets the door open. But we don't know whether he got the door open. So there's some facts that are still out there that I think make the difference. If the door gets opened, I think you have a justified shooting. If the door doesn't get opened and the guy's just pulling on the door trying to get in, I don't think you have a justified shooting until it becomes apparent that this guy can actually enter the truck. So that's my thoughts on it. You guys, please leave me a comment in the comment section. Let me know what you think about it. But the law is very nuanced when it comes to this. You must do things that are objectively reasonable, meaning all the people that have forever and ever and ever to replay these facts out in court, are they going to look at what you did and think, okay, a reasonable person in the same situation would have done that? Or no, I don't think this guy can articulate that he was actually in imminent danger of receiving serious bodily injury or dying. The door's locked and he reaches over top the window and shoots the guy. I think you got a bad shooting there. If the door's open and he's trying to, keep the guy out of the cab and he shoots, I think you have a good shooting there. And I think that is really the issue here. What actually happened? And we're not going to find out until it plays out in court. But I'm going to keep up to date. I'll give you guys updates on it as things change and as more facts come out. But just last week, the judge did bond this over and found probable cause to bond it over. So there's probably some stuff that we don't know yet about why prosecutors here think this is not a good shooting. So I'll keep you up to date, but please remember to like and subscribe. We're almost to 3,000 subscribers. You guys have been incredible. So continue to give us your support. We really appreciate you. And let me know what you guys think about this case in the comments. Thanks a bunch.